Hey everyone, my name is Georgie and this little dude is my hellhound puppy named Native. Welcome to my channel, Georgie's Life Unfiltered.
Ready for an adventure, little buddy? Then let's run! Yay, keep going!
Georgie wakes up with the morning sun, hands folded quiet, the day's begun. She thanks the Lord for the breath she breathes, for open roads and blooming dreams. Faith in her heart like a steady flame guides her steps when the world feels strange. Georgie loves God, stands strong and true, loves her family and all she'll do, loves her country, red, white, and blue. She won't back down, she'll see it through. When the line is drawn between wrong and right, Georgie stands tall, ready to fight. Sunday dinners, laughter loud, lessons learned in a humble house. Mama's prayers and daddy's hands taught her how to take a stand through the hard times, through the good. She remembers where she stood. Georgie loves God, stands strong and true, loves her family and all she'll do, loves her country, red, white, and blue. She won't back down, she'll see it through. When the truth is tested in darkest night, Georgie stands tall for what is right. She knows freedom isn't free, it's a promise you defend and keep with courage, grace, and honesty. She speaks the truth so fearlessly. When the crowd goes the other way, she won't bend just to feel okay. With a steady voice and open eyes, she lifts the weak, she won't compromise. Heart full of hope, soul full of light. She's not afraid to do what's right. Yeah, Georgie loves God, stands strong and true, loves her family and all she'll do, loves her country, proud and free, lives her life with integrity. Through every storm and every fight, Georgie stands tall for what is right. Yeah, through every storm and every fight, Georgie stands tall for what is right.
Good afternoon, everybody. It is so good to see all you lovely people. Yes, today is Charlie Day. I know there's not going to be many people interested in this, and it's really sad that it's not. It's less about politics and more about a life was taken. It's a trial, regardless. It's a human being, regardless of what side of the aisle you stand on politically. This isn't about politics. This is about a life being taken. Nothing was funny about this. But in Tuesday's hearing, Tyler Robinson's defense is one, trying to have the prosecution removed from the prosecutor removed from the case. He is also trying to fight the battle that they don't want media in the trial. This is part 2 of an evidentiary hearing that we saw a while back. I did not air it. I should have. But Charlie deserves justice just like anyone else deserves justice. I'm showing where Fox was showing a couple things before the trial here to my left from the last hearing he had. I personally believe that they have the wrong guy, but that's just my opinion. I think there's more to it. There's no way they caught the shooter this quick. But again, that's the conspiracy side of me. I feel like there's way more to it. Yeah. I see Jimba and Menace and the Native and Voss, Frankie Fuzzface. But like I said, at the end of the day, Charlie Kirk was a human being. It doesn't matter what side of the political aisle he stood on. He lost his life for using his freedom of speech, his freedom of religion. That could have been you. That could have been me. That could have been any of us who choose to use our constitutional rights, no matter what side of the aisle we are on. Yankee! That's right, we are Charlie. I am going to go ahead and pull up. Now, at the very beginning of the hearing, the judge's audio was absolute trash. Let's see. Customize. Let's put me here. There we go. But let's get into this.
Sanctions that are appropriate and proportional under the circumstances. Before imposing any sanction, the court will make specific findings on the record.
Hi, Miss Laura.
In addition, the court may consider any remedial measures, including immediate suspension of video transmission for the hearing in which the violation occurs, with proceedings continuing on an audio-only basis.
By the way, I hunted for better audio, but the judge's mic was just pure trash on every single one of the streams I found. It was the judge's mic. The audio is just trash. Hi, Miss Laura.
And disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for electronic media coverage of the court proceedings for that hearing from serving as pool camera operator in this matter, where such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. Any such remedial measure would be considered only as a last resort and only to the extent necessary to address the specific violations at issue. Counsel will have an opportunity to provide input before the court makes any final determinations regarding sanctions. The court values that input and will give it careful consideration. I want to be clear that these measures are intended to preserve open and transparent courts while ensuring fairness to all parties, and the court remains fully committed to the presumption of open proceedings under the applicable rules. Rather, these measures exist to protect the constitutional rights of all parties while preserving the integrity, fairness, and orderly conduct of these proceedings. With respect to media coverage in the courtroom, the court offers the following additional guidance to assist everyone in navigating today's proceedings. The pool camera has been relocated to the rear of the courtroom. The camera operator shall not zoom in on any individual seated at counsel table. When counsel tables are filmed, the camera must remain in a wide shot that includes all individuals seated at the table. Attorneys and witnesses may be filmed individually when standing at the lectern or seated in the witness box.
Y'all caught that, right? They don't want the camera to zoom in on Tyler, the murderer. How is that fair when it's a public hearing?
I would also ask counsel to be mindful that microphones are located throughout the courtroom and may pick up conversations. Counsel may wish to consider using screen protectors on laptops and taking reasonable steps, such as covering one's mouth when speaking, to avoid the inadvertent capture of private communications, whether by camera, microphone, or those present in the courtroom. Third, the court wishes to address the camera operator. At this time, Mr. Josh Demick, could you come forward to the lectern? Could you please state your name and spell it for the record?
Yes, my name is Josh Demick, Josh Demick.
Thank you. My intention is not to cause you any embarrassment or discomfort, although it's probably not feeling that way on your end. I simply want to ensure that the expectations for today's proceedings are clear. During today's hearing, what is your primary role?
My role is to cover the hearing that we have going on this afternoon, and I have read over the decorum and the EMC as well. My plan is to solely focus on the individuals that will be speaking up here.
All right, you anticipated my next question, which was, have you read the December 23rd, 2025 standing decorum order, which you have, and I appreciate. And do you understand the guidelines as they relate to your responsibilities today, including the additional guidance regarding camera position at counsel table and the filming of attorneys and witnesses that I just put on the record that was not in the decorum order?
Yes, Your Honor.
All right. Do you need any additional time to review the order or to reposition the camera to ensure full compliance?
No, Your Honor.
All right. Do you anticipate any difficulty complying with the order or today's guidance?
No.
All right. Thank you, Mr. Demick.
Thank you.
Before I let you go, as I just asked questions of the pool camera operator, Mr. Demick, I'll turn to counsel. Do you wish to weigh in on what the court has just done?
No, Your Honor, thank you.
Thank you.
Yes, thank you, Your Honor. Richard Novak for Mr. Robinson. May I speak from here?
Yes, Mr. Novak.
All right, thank you, Your Honor. We appreciate that the court, on its own accord, moved the videographer. I don't know where the still photographer is, but we continue to be concerned that any video images of Mr. Robinson during court proceedings, close-up images of Mr. Robinson during court proceedings, interfere with his right to a fair trial. I think I heard everything the court said about the videographer, but the still photographer is still seated in the same place where they were last week, and we would ask the court to order the still photographer not to take any photographs of Mr. Robinson's face or person during the hearing. In the same way that the videographer has now been ordered to be focused on the court, the witness, if somebody's testifying, counsel at the lectern, or generally the people seated at what the court referred to as counsel table. We do not want to see still images again of Mr. Robinson's face in the media with more speculation about meaning of his facial expressions or the lack thereof. And so we really appreciate what the court did on its own, sua sponte, I guess we would say. But we have the same concerns about the still photographer.
All right, and before I address that, any questions as it relates to Mr. Dimick? I want to excuse him to go back. Standing in front of the court is no fun, and I recognize that.
I was just trying to keep him up there as long as possible.
I see. All right, Mr. Dimick, thank you so much.
Thank you very much.
All right, before I address that, I'll allow the parties to be heard before I address what Mr. Novak has brought up as it relates to the still photographer. To the state.
Why are they trying to hide his face? That's my question. What are they trying to hide?
I think Your Honor's appropriately concerned about the video, any close-ups of Mr. Robinson. I'm not sure that a still camera presents the same concern. This is a public hearing, and I think that that it's appropriate that still photography be taken. I don't know that it raises the same concerns that Your Honor's raised with the video.
Thank you. Any other party wish to be heard?
I'll be brief, Your Honor. Michael Judd on behalf of the news media. We agree that with what the state has just said. The concerns that I understand the court trying to address involve the capture of moving lips that can be used by lip readers. We have dealt in the past with inadvertent overhearing of actual conversations. I don't think still cameras present that same issue. The idea that a participant in a public hearing, including the defendant, cannot have their image captured by a still camera because a facial expression is somehow too much to let the public see, we simply don't agree with. It is, of course, the court's prerogative to set the guidelines that it believes are appropriate to balance these interests, but it will come of no surprise to the court that the news media believes that that particular measure of saying even a photograph of a defendant in a public courtroom is too much to allow without threatening fair trial rights in a way that goes beyond that balance. We think that's too far.
All right. Mr. Novak, I do have a question for you. Has there been a violation of the decorum order by the still?
I get that, Miss Laura, but this is just petty demands. I get the lip readers in video. I completely understand it in video, but still images? Come on.
Photographer in any of these proceedings?
I am not aware of violations by the still photographer, but I am very aware, if I may, of what we believe is unfairly prejudicial media content based on the images. And video images, yes, can be embedded in electronic media, but still photographs also are still appearing, still photographs from the courtroom are still appearing in print media and in less, what we've referred to as less formal media channels. So we are still very concerned, and I don't understand why there would be any even marginal negative access to the public to this hearing by the still photographer being in the back of the courtroom and taking photographs of the court, meaning Your Honor, of witnesses on the witness stand, if that's what the court's going to permit, of counsel. I don't have a problem with that. But we continue to have grave concerns of huge photographic lenses being focused on our client. And the results of that. And I'll just make a representation to the court that while we were in court last time, Mr. Burt and I both received, literally in real time, long ranting voicemails from people who were watching the proceedings. Now, that was on video. I received another one of those calls today referring to my client's facial expressions from somebody who decided to leave a long, aggressive message on my office phone. And I'm very concerned that even still images of Mr. Robinson's visage in the courtroom are going to interfere with his right to a fair trial. And we've reached the point, because of the prior violations that have occurred and because of the nature of the media coverage, where Mr. Robinson feels like he may have to make a choice between two of his Sixth Amendment rights. And that's the right to a fair trial and the right to be present. And we want him to be able to have both of those rights, and all of his rights. And the way he can exercise both his right to be present and his right to a fair trial, camera to where the video camera was ordered to be.
Thank you, Mr. Novak. Thank you to all parties. I appreciate your input. This is an important matter, and the court takes it very seriously. I note that there has been no violations of the December 23rd, 2025 decorum order by the still photographer. That being said, this court wishes to exercise caution and will request that the still photographer go behind the bar, to the bar being the separating lower wall, and reposition his camera at that place. I appreciate the patience of all parties as we do this. And again, this court is balancing open and transparent courts with the constitutional rights of all parties involved. All right, while that's occurring, I'll turn to the state. The court would appreciate a brief update on the status of discovery.
Facts me about. Hi, Jaws.
Your Honor, Chad Greenender for the state. To date, we have shared with the defense 100% of what we have received from law enforcement. With that said, we have been informed late last week that there is approximately, there's several terabytes of digital evidence from phones and other digital devices
Hey, this dude has a
that
butt
the
head.
State Bureau of Investigations has in their possession. We are collecting a 20 terabyte hard drive to two of them, one for us and one for the defense. We did receive a letter, I think, this morning from the defense outlining their expectations with respect to how that would be received, original form, and more specifics as well. So we're in the process of coordinating that download onto those hard drives of the digital evidence that's been collected, and we will provide that as soon as we receive that and downloaded to the defense. We are still working with law enforcement on the download of approximately 30 days of all of the surveillance video at UVU. We were told it was approximately 300 terabytes, and that's being downloaded 24/7, so that is still in process. So we're actively working on that and looking forward to collecting that and passing that along to the defense.
I have to say this. Everyone on the planet saw in wide view angle Charlie get shot by Tyler. Why the hell shouldn't Tyler be shown on camera? He's the criminal. He's the murderer. He did what he did. Why shouldn't they show him? They had no shame in showing Charlie get shot. They had no shame in that.
It will need to be shared, in some sort of similar fashion, I'm sure, with respect to hard drives.
Thank you, Mr. Grunander. And does defense want to be heard?
That is correct, Your Honor. Stacey Visser on behalf of the defense. We are in communication with the state about what we believe is missing at this point, and we are anticipating a large amount of digital discovery in the next few weeks that we will need to process.
All right. Thank you.
May I supplement this conversation, Your Honor?
Briefly.
Thank you, Your Honor. We've kind of divided up discovery responsibilities, and mine is to address what I'll call non-digital forensics. So there are many items of seized evidence that have been sent to various law enforcement labs around the country without getting into the details. We have some very, what I'll refer to as summary reports of those evaluations. But as the state attorneys know, we're going to need all of the underlying data, notes. These relate to things like DNA and other forensics. So if we haven't provided them with a very, very detailed list of the types of documents we need, we will. But I think Mr. Grunander could speak to this in more detail in terms of the status of that. But I think that's another big chunk of materials that presumably the state attorney's office has not received yet from law enforcement. And so obviously they haven't had a chance to give it to us, and we haven't had an opportunity to look at it or to have our own experts review those types of materials.
Thank you, Mr. Novak. All right, before the, Mr. Grunander.
We'll make a point to follow up on that with the law enforcement agencies. We'll communicate with defense counsel on that, Judge.
I appreciate the cooperation between the parties. Before the court proceeds further, it's appropriate to address the record. The court notes the recent filing by victim representative Erica Kirk involving the statutory right to a speedy disposition of the charges under Utah Code Section 77-38-7 sub 2. This court raises this issue solely to ensure that the record accurately reflects the statutory obligations governing the matters presently before it, and not to suggest any view regarding the merits or outcome of these proceedings. Under this statute, a crime victim has a right to a speedy disposition of charges free from unwarranted delay. When considering a defendant's request to continue a previously scheduled trial or other significant criminal proceeding, the court must inquire into the circumstances asserted as the basis for delay and must consider the victim's interests in timely resolution together with the defendant's constitutional and statutory rights. The court emphasizes that the defendant's rights to due process, to present evidence, and to receive full and impartial consideration of all arguments remain paramount and undiminished. The court's responsibility to balance these interests faithfully and without preference to any party. As previously stated on the record at the September 29th hearing, justice demands that both of these principles, the rights of the accused and the rights of the victims, be honored without compromise. With that framework established, the court will hear briefly from counsel concerning how you propose proceeding today.
Thank you, Your Honor. Richard Novak, again from Mr. Robinson. We're prepared to continue with Mr. Gray's testimony. We did file what I captioned a renewed request that this court proceed under a particular section of the Utah Code to refer this motion to the Attorney General. So it's obviously up to Your Honor to decide if the court wants to address that renewed request in writing now or at a different time. I do want, whenever it is the court's view that it's timely, to address the issue that the court just brought up, which is how the court, well, what I want to address is how the court will manage the question of whether Mr. Robinson needs more time to prepare for the preliminary hearing. So the court got an update on the status of discovery. The court noted Ms. Kirk's filing, which of course we are all aware of, and we understand her rights as the representative of the victim in this case.
That part, Matt. That part.
There are challenges under Utah law when the defense needs to communicate to the court the details of its diligence in terms of preparation for a hearing, because we're not going to make a public filing of work product. And I'm sure the court understands exactly what I mean.
Yes.
So what I'm saying is the court brought up the filing and the significance of that for future proceedings. We're going to need to have, if I may, what I would call sort of a case management conference at some point about how the court will manage our need to be able to share with the court the status of our work, which we believe is confidential and privileged, in light of the fact that every time we file something and ask the court to designate it as private, we have counsel for the media trying to unseal it. And we also don't intend to disclose to the state the status of our diligence. And so I'm not asking the court to address it now. I guess I'm just trying to put a post-it note on somebody's list. It's certainly on our list, and we didn't really intend to bring that up at the outset of today's proceeding, but since the court mentioned Ms. Kirk's filing, it just seems like the right time to mention that. So we're prepared to proceed with further testimony from Mr. Gray and keep going with the evidentiary hearing unless the court wants to address what I captioned our renewed request.
Thank you, Mr. Novak.
Thank you.
To the state.
And Your Honor, the state's prepared to go forward with the evidentiary hearing. We are prepared also to address this renewed request. If Your Honor would like to do that at the outset, I would suggest that Your Honor set a time limit on that argument so that if, assuming that motion's denied, that we can move on with the evidentiary hearing. We've got witnesses who've been subpoenaed. They're ready to testify.
All right. Well, I appreciate that update, and I do want to give some guidance of how today's hearing is going to go, and both parties have touched upon that. Based on the record before the court as it relates to the evidentiary hearing, and in order to ensure a fair, orderly, and efficient proceeding, the court will proceed as follows. First, we will address what Mr. Novak just brought up in regards to the referral to the Attorney General's office briefly, and you'll see why I say briefly with my next statement. Counsel will have until 4:30 to present evidence, including cross-examination and any redirect. Motions for supplemental briefing are denied at this time, as the court finds the issues adequately framed for today's proceedings. These parameters are not intended to limit any party's substantive rights.
Again, they need to get this man a better mic. Good Lord. The staticky feedback. Rah, 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 rah. Although this judge seems like a really take no shit kind of judge, unlike the potted plant we have in the Hells case, who is just sitting stagnant. Now, the defense attorney, being he moved for all the cameras to be moved to the back, now we all get to see that he has a butt head. Quite literally a butt head.
To keep the proceedings focused and free from any unnecessary delay. Upon the close of the evidence, the court will proceed to argument. Each side will be allotted 15 minutes. Mr. Novak, or to any of the attorneys who would be making closing arguments, if you intend to reserve time for rebuttal, please allocate your time accordingly. This court will conclude at 5 o'clock. And in addition, the court anticipates issuing its ruling via WebEx in order to give the evidence and the arguments presented today the careful and deliberate consideration they warrant. That proceeding will be scheduled at the conclusion of today's hearing. And so, counsel, with that in mind, we will turn to the motion to refer, or the motion concerning the Attorney General's office. I will hear from both parties. It is your time. I am not putting constraints on who you call, what questions you ask, in part, but keep in mind these time constraints as we address this issue. Mr. Novak.
Get him, Judge.
Thank you, Your Honor. We filed what we captioned the
Okay, is it just me or does the judge like give certain annoyed looks when he addresses the defense? Is it just me? It's probably just me, but every time he addresses the defense, he just looks so annoyed.
renewed request because obviously at the last hearing, we brought the request verbally. And obviously the court's read our renewed request and our points and authorities. We received the brief written by Mr. Ballard, which is very clear and very well written, and we understood the views expressed there. We just disagree fundamentally on what that code section means. We disagree fundamentally on the suggestion that there's a separation of powers problem. It is ultimately this court's responsibility to ensure that parties are represented by conflict-free counsel. Obviously, in the legal profession, there is an initial expectation that counsel will avoid conflicts. But there are always situations where a party needs to bring a conflict on the other side to the court's attention, and the court has both the statutory authority and the inherent authority under the common law to do something about it. So we do believe that this is well within the court's discretion. The statute actually tells the court that it needs to encourage the state to seek assistance.
That's true, Jimbo.
That seems to be a gentle way to say that the state.
Okay, being that he keeps saying and so I was watching a short reel the other day that was talking about body language and this, and in people who are of authority, like these attorneys that are constantly having to fill their sentences with and aren't what's the word I'm looking for? Confident in what they are saying. So I think it's kind of funny that this attorney keeps filling his sentences with and It just points out that he's not feeling too confident in what he's saying. Maybe. I don't know. I was just having to point out the fact that I watched that video the other day. And I saw that had to do with another murder trial that I'm also interested in.
Is at least disqualified from litigating its own disqualification issue. And then I'm going to reserve the rest of my time for our evidentiary hearing and closing arguments.
Thank you, Mr. Novak.
Thank you.
Turning to the state, Mr. Ballard.
Captain Big Nose. What is with all these attorneys and big noses?
Your Honor, it feels like Groundhog Day. Here we are, we've got, again, we're supposed to be having an evidentiary hearing, and Mr. Gray should be on the stand, and instead we're arguing again this issue about whether this court can refer this issue to the Attorney General's office. And I guess if I were in Your Honor's position, I'd be wondering why the defense insists on raising this issue in a way that doesn't allow this court or the parties to be able to fully analyze it and brief it. The defense finally did file a written motion, but waited until Friday afternoon to file that. So as we've outlined in our alternative point in our response, I think this court would be well within its discretion to just deny that motion as untimely. But on the merits of that motion, I think, as we've explained in our response, and Your Honor's indicated that you've read that, I think we've explained clearly why this statute does not apply in the way that the defense claims it does. And I'm happy to walk through the statute and the points that we've made. I don't want to belabor that. If Your Honor has any questions about the statute, I'm happy to answer those. But I think it's clear that this statute does.
Hi, Faves. You're good. I can't wait for your video release. And Mac says, in my own opinion, they want to take his wife's voice and rights away and give the killers everything he wants. That does seem that way. But Erica is not the type of woman to shut up. She's not going to back down. So they might as well give it up on that one. Not only Erica, but there are many of his friends, his other relatives, and all of those of us out here who love Charlie that are not going to be silenced. Charlie will get justice.
Does not allow the court to replace a prosecutor. At best, what it allows is the court to recommend that the county attorney seek the help of the Attorney General's office. So I don't believe that this statute has any application. The cases that the defense has cited are irrelevant to this issue. And for those reasons, unless the court has any further questions about the state's opposition, I'd submit it.
Thank you, Mr. Ballard. Anything further from the parties before this court issues a ruling?
No, thank you.
All right. So before this court's defendant's renewed request to refer the pending motion to disqualify to the Office of the Utah Attorney General. In support of that request, the defendant relies upon Utah Code Section 17-18A-304, which provides that the Attorney General shall assist a county prosecutor only if the court finds that the prosecutor is unable to satisfactorily and adequately perform the duties of prosecution and recommends that the prosecutor seek additional legal assistance. The defendant argues that where there exists a non-frivolous basis, factual basis, suggesting a potential conflict of interest, the court should make such a finding and recommend assistance from the Attorney General. The court has carefully considered that argument and reviewed the briefings. However, the statute does not adopt the standard proposed by the defendant, nor does such a standard appear in existing case law or court rules. The statute requires specific findings regarding a prosecutor's inability to satisfactorily and adequately perform prosecutorial duties before referral is appropriate. At this stage of the proceeding, the court is not persuaded by those statutory conditions.
Well, hey, listen, Greg, I know Candace has been a bit crazy lately, but there has been some things that she has put out there that has come out to be true. So not all conspiracies are lies. Not all conspiracies are made up in people's heads. Entirely too many conspiracy theories have been confirmed within the last couple weeks for everything to just be, oh, these people are crazy. With the Epstein files being released, a lot of conspiracies that a lot of us had has been confirmed in those Epstein files. Holy cow. That's a whole nother stream for a whole nother day. But let me tell you, don't always bank on the conspiracies being lunatics. Just saying. The adrenochrome was confirmed in the files. Mac, so you noticed it too, right? I was like, oh, he must be related to Bubbles.
Have been met. Based on the record presently before the court, there is no indication that the Utah County Attorney's Office lacks the resources, knowledge, or ability to litigate the motion to disqualify on behalf of the state. Accordingly, the court cannot make findings required under Section 17-18A-304 to justify referral to the Attorney General's office. For these reasons, and without expressing any views on ultimate merits of the motion to disqualify itself, the defendant's renewed request for referral is respectfully denied. All right, counsel, let's go ahead and proceed. Mr. Ballard.
Thank you, Your Honor. Could I just clean up one piece of the record? Your Honor referred to the statute as 1718A, but I think it's actually been renumbered. It's 17-68-304 is the current citation.
Agreed.
Thank you.
Alicia, I like that name. It's pretty. She is a nutcase. Hey, I will agree with that. She is a nutcase, but like I said, don't doubt all conspiracy theories. I'm not defending Candace. I don't like Candace. But entirely too many conspiracies has been confirmed. But I agree with you. There's no way in hell Erica had him murdered. I agree with that. I'm not discrediting that. Like I said, Erica's the type of woman that's not going to back down. She's not going to shut up. She will fight like hell to have justice for her husband. If Bubbles is Bubbles, this one must be Squeak. I'll have to go back and screenshot that attorney. Because, oh boy, as much fun as we have making fun of Bubbles, we could have a field day with that one.
Appreciate that correction, and that is correct. I appreciate that, and to clarify the record, thank you to both parties. And so my ruling reflects that 17-68A-304. All right, counsel, are we ready to proceed with continuation of the direct examination of Mr. Gray?
Yes, except to quickly implement the exclusionary order that the court entered at the last hearing with respect to prospective witnesses.
All right, the court will take a very brief 3-minute break in order to accomplish all parties speaking with whoever needs to be spoken to and for them to be excluded, and then we will proceed. It is now 1:38. We'll come back at 1:41. Court is in a brief recess.
Bear with me, guys. Let me fast forward through this.
Kirk's death. Child had been like on his death.
Oh. Come on. Let's go.
That it was.
Okay.
No. Not that I can remember. That's completely.
Okay, well, I'll represent to you that it was 5 days after the hearing on January 21st. Does that refresh your recollection at all?
Oh, are you talking about after the hearing? I'm aware of that, yes.
Okay, and
Yes.
how did that come to be? Because you testified that your office has no involvement in the investigation.
Well, it was a point that you had pointed out, and so out of an abundance of caution, I believe it was Mr. McBride that decided to go ahead and do that.
Okay, and have the adult child be interviewed?
Yes.
So it's your understanding that Mr. McBride advised SBI to do that interview?
That's my understanding.
Understood. Okay. You also testified
Tuesday.
on January 16th that you weren't really sure whether your office had a written policy for how to deal with either actual conflicts of interest.
This hearing was Tuesday. Faves.
Or the appearance of conflicts of interest.
Yeah, I assume that they did, but I couldn't point to one at that time.
Okay. And then after the hearing, did you locate a written policy?
I did.
Okay. And at the time that you were discussing with the prosecutor whose adult child we're talking about, the fact that that child had been at UVU on September 10th and had witnessed many of the events surrounding Mr. Kirk's death, Did you actually consult that written policy back in October?
No, but I followed it.
Had you previously read it?
I'm sure I had at some point. I mean, it's a pretty standard policy. If there's a conflict within the office, then, or a potential conflict, then the attorney will notify us, we'll review it and decide whether any action is needed, if at all.
Okay, but when I asked...
That's what we did.
When I asked you on January 16th, is there a written policy? Your answer was, I'm not sure.
Right.
There was a subpoena for documents that you received and complied with over the last week or so, correct?
Yes.
Okay. And one of the things that we asked for in that subpoena was any memoranda or writings that memorialized how your office handled the potential conflict of interest.
As I understood the subpoena, it's any discussions regarding whether or not there is a conflict.
Right.
And so, yeah.
And so what I take from the return on the subpoena, if I could call it that, is that there isn't any memo to the file, there's no legal analysis, there's no memorialization of the decision that you made that there's neither an actual conflict or an appearance of a conflict.
No, there's not.
You mentioned when you were testifying at the last hearing that you are the president-elect of SWAP. Could you just remind the court what SWAP is?
SWAP is a statewide association of public prosecutors, or public attorneys and prosecutors. It's basically a lobbying group with respect to legislative matters that affect prosecution.
And how long have you been a member of SWAP?
For about
As long as you can remember?
the 3 years that I've been county attorney, I've been a member, a board member of SWAP.
Okay. And are you familiar with a document that they produced called Utah Prosecutors Best Practices?
I know that they have that document, yes.
Did you consult that document with respect to what your office should do in connection with the potential conflict of interest or the appearance of a conflict of interest that we're discussing?
I don't believe I consulted it. I relied on my 25 years of knowledge of conflicts and so forth.
Your Honor, what I would like to do, if I may, is approach Mr. Gray with a document that I'm just going to mark for identification as Exhibit I, and that's because we've previously marked for identification A through H, if I have my alphabet correct.
Yes.
And if I may pass one up to the court, I
Really,
will,
Laura?
if the court needs that.
No, feel free to approach Mr. Gray and present
All right,
Exhibit
thank
I.
you. Mr. Gray, I'm handing you something that's been marked as Exhibit I for identification only. Oh, I'm sorry, of course. Have you seen this document before?
I've seen it, yes.
All right.
I mean, there's a lot more than just conflict in our best practices.
Absolutely, but we're just
Yeah.
going to talk about that, okay?
Yeah.
All right, so what I'd like to do is turn your
Grasping.
attention to page 2 of that document, which has a whole section addressing conflicts of interest. Would you agree with me that it starts in the middle of page 2?
Yes.
All right. And you see what I'll refer to as General Standard 1.30, conflict avoidance.
Yes.
All right, could you just read that aloud for the record, please?
A prosecutor should not hold an interest or engage in activities that conflict, have a significant potential to conflict, or are likely to create a reasonable appearance of conflict with the duties and responsibilities of the prosecutor's office.
All right. What do you take to mean the reasonable appearance of conflict?
There has to be a real actual conflict, that there could be actually an appearance of that conflict.
And that would be in the views of the public, right?
That would be based on Supreme Court case law and case law generally.
But it's an appearance. What I'm asking you is, would you agree with me that it's...
So what exactly is the defense trying to say is the conflict of interest here? Does anyone happen to know that? Because I'm confused. I don't know if I missed them saying it or what, but I'm trying to figure out what the defense is getting at here.
That there's an appearance to the public.
Objection. This calls for a legal conclusion, Your Honor.
Mr. Novak.
Well, the witness testified that he's been aware of conflict principles for 25 years. So I think he should respond to that question.
I think this is a good argument to have with the court after the evidence has been presented, whether or not there's an appearance of a conflict, what that means, but I don't think the witness's opinion about it is evidence.
Thank you. I'm going to sustain the objection. Mr. Novak.
Understood. Mr. Gray, why don't you turn to page 3?
Are you kidding? Okay.
And that'll be standard toward the bottom.
Hold on. So I decided to Google it to see what they were trying to say. And it says, the conflict of interest in the Tyler Robinson case arises from the presence of an 18-year-old child of a deputy prosecutor at the Utah Valley University event where Charlie Kirk was shot. The defense argues that this personal connection could have influenced the prosecutor's decision-making process and compromise the integrity of the prosecution. The defense has filed a motion to disqualify the entire Utah County Attorney's Office from this case, citing the concerns about the potential for bias and the need for impartiality in the prosecution of a death penalty case. The defense's claims have been met with skepticism from legal experts who suggest that removing an entire office may be challenging given the complexities of the case. Are you shitting me? So just because the prosecutor's son or child, I'm sorry, went to that school and could have been present the day that Charlie was shot, that triggers a conflict of interest? So could the defense be grasping? What do y'all think?
One 3.3C. Do you see that?
Yes.
Okay, could you read 1-3.3C aloud for the record?
If a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal.
All right, Mr. Gray, I want to ask you some questions about the decision to file it.
I pulled a Georgie. I muted myself. And they're wanting to remove the entire office because of one person's child. Okay, I could see them wanting to switch to someone else in the prosecution office because of his child being there, but removing the entire office. Alicia says they are doing exactly what Erica stated in her motion, that all they are doing is stalling the inevitable. Right, Joan? Exactly. The prosecutor wasn't there, but his child was. But okay, so put yourself in the prosecutor's shoes. If your child was a member of that community, of that school community, and there was a shooting at that school where your child attends, wouldn't you feel a little biased because your child is there? I don't know. Either way, I feel as these people are professional enough to put their personal feelings aside and be professional.
Notice of intent to seek the death penalty against Mr. Robinson, and the fact, which is beyond dispute, that a adult child of a member of the prosecution team was present at the shooting of Mr. Kirk, all right? You state in your opposition, well, let me back up. You testified on January 16th that you are the one who drafted the opposition to the motion to disqualify, correct?
Yes.
All right. So even though there's no affidavit by you, you stand by the contents?
Yeah, I said to the extent that we could either proffer that information or testify, and here I am.
Okay. So my first question is there a formal written policy or guidelines or procedure, I don't want you to get hung up on my nouns, for when your office decides to seek or not seek the death penalty in a case?
Anytime that it's an aggravated murder case, there's a potential for that.
Okay, so I understand that because that's what the statute says.
That's right.
But my question is there a policy, a procedure, a protocol, something in writing?
No.
Okay. And is it your view that it's your decision alone because you're the elected county attorney?
Yes.
Okay. And in this case, did you discuss that question, whether the state should seek the death penalty, with your team before that decision was made?
Yes.
And did that conversation include the adult prosecutor whose child is the adult student at UVU we're talking about?
No.
Are you saying that prosecutor was specifically excluded?
No, maybe I misunderstood your question.
Okay.
I thought you asked whether or not we discussed her status as a witness.
Let me back up, because it was a bad question if you didn't understand it.
Okay.
Those are the rules, right? Okay. So you discussed with your prosecution team whether or not the state would seek the death penalty against
Yes.
whoever the state accused of committing that crime?
Yes.
All right. And
I should back up. I mean, I don't know that we had a discussion before they actually had an arrest. I mean, that was 2 days later, but certainly in between the time that we filed and then we did have a discussion.
Okay, so what you're saying, if I'm not trying to put words in your mouth, but just so the record is clear, is that after Mr. Robinson was arrested, your team had a conversation about whether or not it would file a notice of intent to seek the death penalty?
It was rather informal. I don't know that we all got together and said, what are we going to do? I would talk to different members of my team.
Okay.
But I had pretty much made up my decision. And so they knew where I was going.
Did you make up your decision before there was an arrest?
I thought that based on if we had the evidence that, yeah, we would be seeking the death penalty.
And you were already aware at that time that the child of one of your team members was present at that event, right?
Sure.
All right. Now, what you're saying is that and that you discussed that with all of the team members, even if informally?
As far as the death penalty?
Yes.
Yes.
Okay. And you didn't exclude from that
No.
conversation the prosecutor whose child we're talking
No.
about? That prosecutor was included in the conversation
Yes.
about whether to seek the death penalty?
Yes.
All right. And you're aware, because I think you were present, that there were a number of press conferences held by elected state officials both before and after Mr. Robinson's arrest, correct?
Yes.
Okay. The governor, who's a former licensed attorney in Utah, held a press conference on September 10th. Were you present there?
Probably. I was present at two different press conferences.
So there was one on the 10th and one on the 11th?
I know he made other statements as well, so I'm not quite certain. I know that I was at two different press conferences.
So when Governor Cox announced at a press conference that the state was going to seek the death penalty, had you already told Governor Cox that that was your decision?
I believe his statements, the only thing that I can remember of his statements is he said, by the way, or something to that effect, Utah has the death penalty. And so that's the one statement that I'm aware of. I mean, it wasn't exactly a demand for the death penalty, but so, I mean, the death penalty, ultimately, I made my final decision by the time we filed charges, if that's.
Okay, but the question I asked you was, had you discussed with the governor your intentions?
At some point, I did. I told the governor that I intended to seek the death penalty.
And was that before Mr. Robinson was arrested?
I don't recall if it was before or after.
Okay, I'm going to represent to you, and we can file an exhibit on this in a bit, that on September 11th, the governor said at that second press conference, we are working with our attorneys, getting affidavits so we can pursue the death penalty in this case, and that will happen. And you were standing next to him when he said that, right?
I probably was.
Okay. Had you already told him that you've discussed this with your team and this is our decision?
I may have. I remember telling him that I would be seeking the death penalty.
What does it matter?
Did you tell the governor that the child of one of the members of your office was present at the shooting?
No.
Did you tell anybody else in state government that the child of one of the members of your team was at the rally?
Not that I can recall. It just wasn't part of my thinking.
They really just call that a rally.
Are you aware whether
on.
the member of your
Hold on.
team told?
You caught that, right? They called it a rally. That's not what that was.
The governor or anybody in state government about that?
I don't know. Certainly not when I was in the room with them that I can recall.
Now I'm going to ask you the same questions about federal officials. Did you inform any federal officials that one of your prosecution team members, a senior member of your office, had a child who was there at the time of the shooting?
No.
Did you tell anybody in federal government or federal law enforcement that you were going to be seeking the death penalty before Mr. Robinson was elected? I'm sorry, before Mr. Robinson was arrested?
I mean, when I talked to the governor, Kash Patel and Dan Bongino were there as well, so they heard my statement that that's what I intended to do.
Okay. And were you aware that before you filed that notice, the President of the United States when on national television said, "I hope he gets the death penalty"?
I had heard that he said that, yeah.
I get that, Jim, but however, it wasn't just the prosecution's office that wanted the death penalty. The entire country pretty much wanted the death penalty. Exactly, Mac. That's exactly what they're doing. They're trying to keep that boy alive as long as possible.
Yes.
That was before you filed the notice?
Yes.
All right. Now, you stated in your briefing that your decision to file the death penalty notice when you did was partly because you ran for elected office 3 years earlier on a commitment to seek the death penalty.
Yes.
So you made a commitment. Sometimes we call that a campaign promise. I'm not trying to make light of it, but that is what we frequently call commitments that we make to the voters, right?
It was a commitment that I would seek the death penalty in all appropriate cases.
Oh my God.
And you knew before you filed the notice that the governor thought it was an appropriate case?
Yeah.
And the president thought it was an appropriate case?
Yeah.
Did Mr. Patel express his views?
Not that I recall.
What does it
I mean, he was
matter?
doing the bidding of the president, so, but I did find it a little interesting, Governor Cox, because he plays no part in the decision. So.
Did you tell Governor Cox after he made those public?
Okay, this is my personal opinion, but I think every state should have the ability of the death penalty. It needs to be brought back. Not just for these high profile cases, but for any instance of a case that is deserving of the death penalty. An eye for an eye, right? And another one. Dead pedophiles don't reoffend. Just saying.
Statements. This is not your decision, this is my decision?
No.
Was it important to you that the people you selected to be on the team for this prosecution remain on the team? I mean, you handpicked this team, right?
I did handpick this team.
All right. And the person whose child we're talking about is a long-standing, experienced senior member of your office,
Yes.
right?
Yes.
It was important for you that they be part of this case.
I want the best people on my team, and I believe I chose the best people.
May I have a moment?
Of course.
Thank you, Your Honor. We have no further questions for Mr. Gray. And if I may, what he told me is that he, after the examination, I assume that there's some cross-examination, he'll be available to be on call, so we don't need the court to address that with him, but he's going to leave the building, which is fine with us.
Yeah, but I'll be available to come back if needed.
Thank you, Mr. Gary. Thank you, Mr. Novak.
Thank you. And I'd just like the record to reflect that it's 5 minutes after 2 when I've concluded my direct.
I appreciate that.
Did you?
Not yet. Not yet.
To the state, Mr. McBride.
I'm going to refer to the prosecutor in your office whose child was present at the shooting as Prosecutor A. Do you know who I'm talking about?
Yes.
Have you ever met Prosecutor A's child that was present at that shooting?
Not that I could remember. I could have in passing, but not that I can remember.
Did the presence of Prosecutor A's child have any effect on the decisions you've made in this case?
Zero.
Did that child's presence have any effect on your decision to seek the death penalty?
Zero.
Why did you choose to seek the death penalty in this case?
Because the evidence that had been gathered supports the aggravated murder charge, and I believe that the death.
Hi, Miss Patty and Sunrise. How are y'all? Good to see y'all. Good to see you too, Miss Joan.
Penalty is entirely appropriate in this particular case.
On September 10th, you've testified that you learned that Prosecutor A's child was present at the shooting, correct?
Yes.
Did her presence affect the decisions you made on September 10th at all?
No.
Will you describe how her presence affected your decision-making on that day and in the few days following before you charged?
It had no effect whatsoever. I mean, quite frankly, as I think I testified earlier, I didn't even give it a second thought after I was told about that.
There's been some question about the reason you chose to seek the death penalty at the time you did. Now, the law in Utah allows you to wait to announce the decision to seek the death penalty until after arraignment, correct?
Yes.
Why did you give the notice of intent to seek the death penalty at the time you did rather than waiting?
I had learned from experience in a prior case in particular, the Michael Jane case, that in a highly publicized case, the longer that you delay that decision, even though, I mean, I may very well make the decision early on, and I have in certain cases, but the more delay, then it just creates all this unnecessary public speculation and everything else. And we actually, in the Michael Jane case, I went to my attorneys and they said, yeah, we usually wait. So I was waiting, but then Channel 2, I believe it was, contacted me and said that they had learned information that we were taking the death penalty off of that case. And so I had to hurry and call them before that, say that's not true. And within a month, I filed the death penalty. But it creates unnecessary angst with families of victims. I knew that this particular case was, talk about publicity, it's even more so in this case than it was in Michael Jane case. And I wanted to shut that out so that we didn't have to deal with that, and so that Erica Kirk didn't have to deal with that uncertainty.
Okay, as you made the decision in this, so that's the reason you made the decision at the time you did, is
Yes.
that right?
Yeah.
To avoid that uncertainty, speculation, and so forth?
Yes.
Was that decision made because Prosecutor A's child was present at the event?
No.
You talked about a campaign promise. When did you run for county attorney and make that campaign commitment to voters that you would seek the death penalty in appropriate cases?
It was,
What year?
it was about 4 years from this very time.
Okay.
So
At that time, did you know Prosecutor A?
I knew of him, but because I had handled,
Had you met him personally and interacted with him personally? Or
No.
You just knew who he was?
Yeah.
Okay.
At some point after I won the election, I met with him and others to determine who.
Understood. But at that time when you were making that campaign commitment, was it because you knew Prosecutor A?
No.
Okay. Was it because Prosecutor A had an adult child?
No.
Okay. Decision-making. As far as the decision-making in this case goes, who makes the ultimate decisions on major decisions in this case?
I do.
Does Prosecutor A, does the buck stop with Prosecutor A?
No.
There's been some evidence that deputy county attorneys in your office went to the command center at Utah Valley University on September 10th and the days after that.
Yes.
Is that a normal process?
Yes, in any homicide case or big case, we'll have attorneys respond to the command post to offer any assistance that may be needed, which may include search warrants or discussions about, the need for certain evidence.
So having attorneys appear at Utah Valley University that day was not unusual?
How many? I mean,
No, my question is, having attorneys
yeah,
appear
no,
at the court.
not unusual at all.
Do you know which attorneys went?
Yes, I know that I went.
Can we also point out the body language change in the man on the stand? Like when the defense was questioning him, he just looked at him like, "Are you retarded?" And now that he's being questioned by someone else, it's like he feels more comfortable to answer questions. Y'all notice that? Like, there's an energy change there. Be safe, Mac.
Mr. Grunander went. You went. Ryan McBride and David Sturgill went. And I don't believe any others. Somebody else may have gone there for a short period of time, but I don't recall seeing them there.
Did those attorneys go there because Prosecutor A's child was present?
Not to my knowledge, no.
Aside from charging, have many major decisions, aside from charging and the notice of seeking the death penalty in this case, have many major decisions been made in this case?
I mean, major decisions. No, I mean, what comes to my mind is one major decision was to make sure that defense counsel gets discovery in a timely manner. That was, quite frankly, foremost on my mind once we filed the case. And I personally directed procedures to be put in place so that there would be no mistake as to what the defense counsel received and what we had. I mean, every time there's a motion, obviously the team is working on it. We work on it together. But I mean, as far as trial strategies or things like that, none of those decisions have been made.
Is it fair to say that aside from charging and the death penalty decision, is it fair to say that the most important decisions are yet to be made in this case?
Yes.
And that includes trial strategy.
Yes.
Preliminary hearing strategy.
Yes.
Any plea negotiation.
Yes.
In all the decisions that have been made up to date, has Prosecutor A's child come up in those decisions?
No.
I should say, aside from this motion.
Aside from this motion, yeah.
And so aside from this, I'm going to ask that question again to make sure the record is clear. Aside from this motion to disqualify the Utah County Attorney's Office, has Prosecutor A's child come up in any of the decisions made in this case?
No.
Has Prosecutor A's involvement in this as a witness here affected the prosecution in any way in this case, in your opinion and observation?
No.
Do you believe it will affect the prosecution in the future?
No.
Why not?
Because this is somebody that happened to be there. That has, what we're concerned about is the evidence supporting the charges. That's first and foremost. And that has nothing to do with somebody that happened to be there. Quite frankly, completely irrelevant to anything that matters in the case.
Okay. A couple other follow-ups. Earlier, you testified that Prosecutor A received a you were with Prosecutor A when Prosecutor A received a message from his child that Charlie Kirk had been shot.
Yes.
Is that right? And then you testified that Prosecutor A left to go to the scene. Do you know why Prosecutor A left? Was it to go to the scene and help law enforcement or to be with his child?
To assist in any way we can with law enforcement.
Okay. You previously testified that you did not consult the Attorney General's office about whether or not this was a conflict of interest that would require your office to leave the case or to refer the case. Why did you not consult the Attorney General's office?
Because what they would have done is, researched it and then come back, and I've done that for, over 30 years in my practice. I'm capable of doing that.
Researched it where?
Case law and so forth. Again, I do not believe that there's any conflict whatsoever. I made that conclusion. I stand by that. Out of an abundance of caution, we certainly notified counsel out of an abundance of caution, and I think that's the appropriate action to take. Again, I understand what the concern about conflict is whether or not it has any possibility of affecting your decision-making as a prosecutor, and I didn't see how this does in any way.
Okay, if I can have just a moment. You said you had some neighbors that had children that attended the event where Mr. Kirk was shot.
I was told that they were there, yeah.
When did you learn that those people were there?
Simba, I see you.
I don't know, a couple weeks after, I believe, after the event.
After the charging decision was made?
Yes.
How closely do you know the children that were there?
Not well at all.
Okay.
Maybe a hello or something out on occasion, but as far as I know, I'm not even sure that they even live in our ward at all at this point.
Okay. Thank you.
All right. Mr. Novak.
No, thank you, Your Honor. I don't have any redirect at this time.
All right. As previously discussed, may Mr. Gray be excused?
For now, yes.
Thank you. Thank you, Mr. Gray. Mr. Novak, your next witness? Or I'm sorry, Ms. Nestor. Your next
Your Honor,
witness.
at this time, we were going to call the adult child, but I believe that individual's attorney, they're ready? Okay, then they are ready. So we would like to proceed with calling the adult child at this point. I think it would be appropriate to hear whether or not we close the hearing or at least come up with some ground rules about preventing any photography or mentioning of a name, however the court desires to handle it.
Thank you. I'll hear briefly from the parties. I did read the proffer of facts regarding the closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office. And I'll hear any additional argument or statements prior to making a ruling.
Your Honor, Ryan McBride for the state. We do move to close the hearing for the testimony of the adult child. I think the rationale that I explained previously still stands. The rules of judicial administration allow closure for privacy and safety reasons. I believe with the proffer of facts that the defense has accepted here, we have shown that there are privacy and safety reasons that favor closing the hearing. Defense counsel has stipulated to closure of this portion of the hearing. The media in the past has stipulated to closure of the hearing. I think the record is adequate. I think the safety concerns support closure. And absent any questions from the court, I would make that motion now.
Thank you. Anything further from the parties?
No objection, Your Honor.
All right, so the prosecution cited to the media. Did you want to weigh in?
The media does not object to the closure of this portion.
Thank you. The court has reviewed the parties' prior arguments and materials submitted in advance of today's hearing, including the filing entitled Proffer of Facts Regarding Closure of Portions of the Evidentiary Hearing on the Motion to Disqualify the Utah County Attorney's Office. The defense has requested that the testimony of certain witnesses, specifically Prosecutor A, an adult child witness, be received in a closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, this court is required to consider countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and maintain confidence in the judicial process. This court must also be mindful of the constitutional rights of Mr. Robinson, as well as the constitutional and statutory rights of Ms. Erica Kirk in her role as victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, referred to as deputy county attorney in one of the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, and that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at today's hearing. If the adult...
A crow named Simba? I mean, I'm digging that. We could give the crow like a golden color. I'm picturing it. Dennis, get on it. A crow with the colors of Simba from Lion King. But the crow's name is Simba. I'm just saying. I think it would be cute.
Child witness is called to testify, which is the request at this point. The court will consider that testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the adult child witness's testimony is not necessary and would not be narrowly tailored under the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and that the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and defense to conduct the adult child witness's testimony in closed session is partially denied.
Ooh.
The court acknowledges that Utah Rule of Judicial Administration 4-202 permits limited closure of court proceedings in appropriate circumstances, and also acknowledges the concerns raised regarding the personal privacy and the safety of the adult child witness. This court's responsibility is to balance those concerns with the constitutional rights of the parties and the strong presumption in favor of open and transparent.
Okay, how about the fact that the judge come in here already prepared with the denial of this? Like, I like this judge. This judge is very take no shit. I like it. Picasso.
Transparent judicial proceedings. Therefore, the court finds that a brief and narrowly tailored procedure is appropriate to address these competing interests. Accordingly, the courtroom will be temporarily closed, and all parties and members of the media will be excluded for the limited purpose of calling the adult child witness to the stand to state identifying information. Once that limited portion of the proceeding is complete, The courtroom will be reopened, and members of the public and the media will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed, and no photographs of the witness will be taken. At the conclusion of the adult child's witness's testimony, audio and video transmission of the hearing will resume and will continue through the remainder of the proceedings. The court finds that this procedure is narrowly tailored, uses the least restrictive means available, and appropriately balances the interests of witness safety and privacy with the public's right to observe these proceedings. We will proceed accordingly. We will take a brief, we will go ahead and clear the courtroom and go into a closed session. And the only remaining parties will be the attorneys, and we will take it from that point. The court will be in brief recess for 2 minutes.
All right.
Bye, Laura. Have a great rest of your day. Brah. Let me. I got Mr. G in the background making noise. Come on.
That was the testimony of prosecutor.
All right, here it goes.
His child and target his child. For that reason, I would ask to oppose the testimony of prosecutor.
Defense.
We join in that motion.
And is the media wishing to weigh in on this portion?
Again, the media does not object to the closure of this portion.
All right, thank you. Let me address this issue. And a lot of this is repetitive, but being that this is a motion being made, I will put on the record the preamble to my ruling. The court has reviewed the parties' prior arguments and the materials submitted in advance of today's hearing, including entitled Proffer of Facts Regarding Closure of Portions of Evidentiary Hearing on Motion to Disqualify Utah County Attorney's Office. Defense has requested the testimony of certain witnesses, specifically Prosecutor A, adult child witness, be received in closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, the court is required to consider the countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and to maintain confidence in the judicial process. The court must also remain mindful of the constitutional rights of Mr. Robinson, as well as the statutory rights of Ms. Erica Kirk in her role as victim representative. And I also note that she filed today notice in regards to open and transparent courts. So I just want to touch on that. I acknowledge that filing as a victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, which was previously referred to as deputy county attorney in the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at this hearing. The defense asserts that the prosecutor's familial relationship with a witness creates a concurrent conflict of interest implicating Mr. Robinson's due process rights. The prosecutor's role, duties, and actions in this matter are therefore relevant to the issues before the court. If the prosecutor is called to testify, as it seems they will be, the court will consider the testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and in the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the prosecutor's testimony is not necessary and would not be narrowly tailored on the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and the defense to conduct the prosecutor's testimony in a closed session is respectfully denied. You may call your next witness, Mr. Burt.
Your Honor, I call Prosecutor A.
All right.
And I assume from the court's ruling, we do not need to do a closed session as to his identity?
We will not be doing a closed session as to his identity.
Thank you.
All right, well, go ahead and swear in the witness.
Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Burt.
Thank you. Good afternoon, sir.
Good afternoon.
Could you tell us your name, please?
Chad Grunander.
And could you tell us what your business or occupation is?
I'm a prosecutor at the Utah County Attorney's Office.
How long have you been a prosecutor at the Utah County?
Almost 22 years.
Sir, in front of you, there's a number of exhibits, and they're marked, I believe, D through G. Do you see those there?
Yes, I do.
Okay. I'd like to go over those briefly, and then we'll proceed with your questioning. Do you recognize Exhibit D?
I do.
And could you tell the court what that is?
This is a biography that lists my name, my title at the Utah County Attorney's Office, with a brief description of what my duties are, my responsibilities, my education. It speaks to a little bit about my career and some of the cases that I've prosecuted over the years.
Your Honor, I'd move into evidence D, Exhibit D.
To the state?
No objection.
This exhibit is received and admitted into evidence.
Thank you. Next, Exhibit E. I wonder if you could identify that for the court.
Yes, this is an email that I sent to you as well as co-counsel for Mr. Robinson. It looks like I copied our prosecution team on this email as well. It was an email that was sent on the morning of October 1st, 2025, that disclosed an issue that came up with respect to this case that we felt was important enough to tell you, let the defense know.
Thank you.
This is my email.
I'd move E into evidence, Your Honor.
To the state.
No objection.
E is admitted into evidence and received.
And how about Exhibit F?
Yes, I see that. This is a photograph. It looks like it's a still shot from probably a TV screen from a Fox News alert that shows the amphitheater where Mr. Charlie Kirk was killed on September 10th.
And was this photograph used by you and an investigator to take some measurements out at the scene at some point?
It was, yes. In the middle of the photograph, you can see a dark bag. It's actually a dark blue bag that belonged to my daughter. She was at the scene on that day when Mr. Kirk was shot and killed. And I don't know if this was sent to me or I found it, but that indicated where her bag was left behind when she left the scene. I used this along with an investigator to determine the approximate distance where she was standing when Mr. Kirk was shot and killed.
And what was that distance that you determined?
85 feet.
When did you make that measurement?
That measurement was done the day before, I believe, that I sent the email. So I believe that would have been September 30th of 2025.
Okay. Move that into evidence, Your Honor. Exhibit F.
The state?
No objection.
It is received and admitted into evidence. Thank you.
And Exhibit G.
Yes, I see that.
And could you tell the court what that is?
It looks like it's an email from Ms. Nestor, co-counsel, from Mr. Robinson that was sent to you as well as other attorneys, defense attorneys on Mr. Robinson's case. I became familiar with this document when you, Mr. Burt, sent this to me about 2 weeks ago or so. And that was the first time I recall seeing this and reading it. Some of it is redacted.
Right. Does that email, the unredacted portion, relate to a conversation that Ms. Nestler had with you on October 9th of 2025?
Yes, I can't say for sure it was October 9th, but we had a conversation on that day or right around that date over the phone, and Chris Ballard was also present with me. But yes, this reflects that conversation.
All right, and I move that into evidence, Your Honor.
As it relates to G?
Before determining if I object, I'd like to prepare a witness on the accuracy of this, the contents of this.
Let me ask if I could one more foundational question that could go to that.
Sure, we'll go to Mr. Burt and then to Mr. McBride, and so
Thank you.
It's not admitted into evidence just yet.
Did I send you that email for the purpose of you reviewing it and making sure it was accurate?
You did.
And did you have a response back to me as to whether or not it was accurate and how you would agree or disagree with the content?
I did. I don't know that it's word for word accurate, but the substance essentially is accurate. This is what we talked about and what was communicated.
All right. With that, I would renew the request to introduce G.
To Mr. McBride.
I will say, one.
Counsel, just no questions been asked. I'm just waiting for Mr. McBride.
If I can provide a witness about the contents here.
You may.
Sure.
Did you write this email?
I did not write this email.
This was an email that was sent between defense counsel that memorialized your conversation with defense counsel. Is that right?
That's correct.
Okay. I want to ask you about some of the contents here. Chad is sure he talked with a few people in the office about his daughter's presence. Is that accurate?
Yes, that's accurate.
Does that give a time frame for when you talked to the people about your daughter's presence?
This does not give a time frame.
It obviously had to be before October 9th, right?
Correct.
He definitely shared it with the whole, and I'm quoting again, he definitely shared it with the whole prosecution team prior to notifying us. Is that accurate? Did you speak with every member of the prosecution team, meaning all the attorneys in your office, about your daughter's presence?
All of the attorneys assigned to this case?
Yes.
I believe so. I don't think I spoke to them, each one individually, but they would have been present when it was talked about at some point, I'm sure.
Okay, let's see. Okay, I think that's all I have.
Thank you, Mr. McBride. And defense has renewed their motion to admit G into evidence to the state.
I don't object to the admission of G. The accuracy has been addressed by the witness, so.
All right. Exhibit G by defense is admitted into evidence. Mr.
Thank you.
Burt.
You want to make a clarifying comment?
I did. Right towards the end, before the redaction, it says his daughter has not been interviewed by any law enforcement. That was true at this time. I believe since then, she has been interviewed by law enforcement, my daughter.
Right. So when that was written on the 9th, she had not been interviewed by law enforcement.
That is my understanding, yes. That's correct.
When was she interviewed by law enforcement?
I believe it was after our last hearing in between January 16th and today.
And can you tell me what role, if any, you had in arranging that interview?
I didn't have any role in that. I was just informed that it was going to happen.
Okay, thank you. Now, I'd like to direct your attention to September 10th, 2025. Can you tell me where you were around noon of that day?
I was up in Davis County, in Layton, at a convention center. I was there with my boss, Jeff Gray. I was actually presenting to the elected county attorneys in the state of Utah at a conference.
And was anybody else from your office present at that conference?
No, just the two of us.
Did something happen in relation to your daughter while you were at the conference?
Yeah, shortly after I finished presenting, we were standing around. I was standing next to my boss and some of the other county attorneys in the state, and I started to receive some texts from my daughter that were sent to our group family text group.
And can you recall for me what the content of that initial text was?
Yes, there was a text that came in, I think at 12:25, I believe, that was in all caps, and it said someone was shot or someone got shot. There was another text that came in, I may have seen it at the same time, but it's the same timestamp that said something to the effect, I'm okay, everyone's running inside.
Okay. And just to refresh your memory, we were recently provided with some of your daughter's emails and screenshots, one of which was a screenshot of a outgoing phone call to you at 12:28 p.m. Do you recall that?
I do. I believe I actually tried to call her, and I don't think she picked up, and then she called me.
All right, and according to the screenshot, that was a 1-minute call. Do you recall what was said during that conversation?
I think I was checking on her well-being to make sure she was okay. I don't know that we even talked too much about the facts, what occurred. It was a short phone call, but I wanted to make sure she was okay. That's why I called.
Sure. What was your initial reaction when you learned that she was present at what probably you didn't know much about at that point?
Well, I was startled. I was concerned for her welfare. I understood almost immediately when I found out about it that she was okay, that she was out of danger, but it was concerning.
Now, did you know that she was attending this event?
I did. She had talked about it in the days preceding that she was going to go to this rally.
And did you have some discussion with her about whether that was a good idea, bad idea, or you had no position on it?
No position. We didn't talk about that.
And what did you talk about in relation to Charlie Kirk? This is before September 10th.
Just that I had become aware, probably through her, that he was coming to UVU. She would watch Charlie Kirk from time to time online, and she was excited to go see him at this rally.
Okay, so 12:28, you have this phone call with her. And then do you recall you communicating back with her by way of text?
Yes, I remember asking her a question a few minutes later, asking whether she heard what sounded like a gunshot.
And is that the reference? I think it's attached to the opposition to the motion as Exhibit B, an entry at 12:35.
That sounds right.
Hannah, did you hear a gunshot or what sounded like a gunshot?
That's correct.
That was from you to her by way of text.
Yes.
And did you get a response back from her?
Yes, she responded, I for sure heard it. Everyone started screaming and running. A few people said they saw the shot hit his neck, ... Not sure.
So at that point, did you share the email exchange or the text exchanges with anyone, either verbally or actually sending the text to anybody?
I know I spoke with Jeff Gray about these text messages. I may have even alerted him to the fact that there had been a shooting prior to even sending that text to my daughter, just because we were right there together. But we did talk about that briefly. Within a few minutes after receiving that last response, I know I called our office. I spoke with Chris Ballard to put him on notice that this had happened at UVU. I don't believe it had hit the media yet, news media anyway. And then shortly after that, I also called David Sturgill, another prosecutor in our office, to make him aware of it and to ask him to make himself available for questions and to assist law enforcement with any questions they might have while we, Mr. Gray and I, needed to travel down to Utah County.
And were you still at the location of the conference when you were making these calls?
I believe so, yes.
When did you actually leave to head to UVU?
Probably, I want to say I made that last phone call to Mr. Sturgill about 12:44. I think probably by 12:50 or so, I was probably on the road heading down to Utah County.
Do you recall, again, this is referencing Exhibit B to the opposition, at 12:40, you sending a text to your daughter, quote, I'm getting live information, but I can't share it right now.
Yes, I remember. I think that was on the family group text.
Yes.
I think there was chatter on that group text from my sons. I think my wife as well. I think someone may have asked me, can you tell us anything or what's going on? And I just let them know I'm learning things, but I can't talk about it.
And when you say you were getting live information, who are you getting live information from? Do you recall?
Can you remind me what time that text was?
That was 12:40 p.m. on the 10th.
I do not recall, counsel.
Okay.
I think I had just communicated with my daughter is all. I don't know if in those text exchange, I don't know if my kids were online and seeing something through social media that they were sharing with me. I'm not sure.
Okay. Before you left to head to UVU, did you speak to anybody else in your office?
I believe it was just Chris Ballard, David Sturgill. It's possible I may have spoken with a legal assistant of ours, maybe Haley Christensen, maybe Tammy Painter, but I don't specifically recall that.
And of those people you spoke with, who did you mention your daughter was present at the event?
I don't have a specific memory telling Chris or David about my daughter, but that's how I learned about it, so I'm confident that I shared with them that my daughter was present when this happened, and that's how I found out.
Did you drive by yourself to the UVU?
I drove down to Orem and parked my car near the In-N-Out in Barnes & Noble. Jeff Gray met me there. He came down, left probably 15, 20 minutes later after I did. We met there, and then the two of us drove from that location to UVU.
And what did you do there at the scene once you got there?
We tried to understand what was happening. It was quite chaotic. There were a number of local law enforcement agencies that were already there present. Federal law enforcement agencies were arriving. We were trying to connect the dots as far as what had happened, make ourselves available to answer questions, to assist in reviewing warrants, for example, which did happen later. It was just very busy, very chaotic.
Sure. How long did it take you to get from the conference to the scene?
Oh, probably took me approximately an hour to get down there, maybe less. I waited for Jeff for a few minutes, and it probably took us 10 minutes to get into the command scene.
During that time period, did you have any communication with anybody about where your daughter was? At that time?
All right, guys, we are at our 2-hour mark. Holy cow. I am going to finish this off tomorrow. Timestamp mods, if y'all hear me. 2 hours and 24 minutes is my timestamp on this. I appreciate those of you who came and have watched this with me today. I have a lot to do this afternoon. Our couch comes tomorrow, so me and Mr. G have got to do some moving around of things and some deep scrubbing of these floors. It's dog hair galore. I love y'all. I appreciate y'all for hanging out with me. We will finish this up tomorrow. So Gremlin will be back same time tomorrow. Remember, guys, you are one of a kind. Never, ever, ever let anyone dim your light. You matter. I love you. And I'll see y'all tomorrow. Gremlin out.
Goodbye for now, but it's not goodbye forever. Oh, that smile will be back.
Goodbye.
That clever.
Bye-bye. See you later.
From the jokes to the cheers to the fun we found somehow. Take a bow. It's goodbye for now. When the stars start to glow and the moon waves high, every ending's just a wink, not a last goodbye. So keep that magic, don't you let it slow you down. Goodbye for now, goodbye for now, goodbye for now. We'll slide back in with a laugh and a song, saying we're right where we belong. Till the next adventure, take a breath, take a bow. Goodbye for now, goodbye for now, goodbye for now. So turn off the lights, let the dreams run wild. Keep that wonder, every kid, every child. When the theme song plays, you'll know how we're back again. But goodbye for now.